Morning, Your Honor. Wade Gochnour on behalf of the City of Henderson for moving.
Morning. All right.
Morning, Your Honor. William Schuller on behalf of plaintiffs.
Morning.
Good morning, Your Honor. Joel Tasca for the Las Vegas Review-Journal.
Good morning. All right. City of Henderson's motion for permissive joinder pursuant to NRCP 20A1 or alternatively motion to intervene pursuant to NRCP 24. I received a notice of non-opposition. That was filed yesterday.
Your Honor, we've received one from both the plaintiff and the defendant. I think we're fine on that. The only issue I have
Is it going to be a joinder or a intervention?
Well, I think intervention makes the most sense because we filed a complaint in intervention. But again, from a foundational point, with all due respect to the defendant, as I was thinking about when I saw the non-opposition this morning, and in all fairness, they tried to submit a stipulation yesterday. I didn't see it until after hours. We kind of talked about it a little bit, but they're trying to reserve the right. My concern is this. They're not fighting us here. They say, come on into the action, but it appears that they're really hoping to, at the end of the day, file some sort of anti-SLAPP or something along those lines. I don't know that that's appropriate, Your Honor. If they had a problem with us being with this case or bringing this case in the first place, I think that should have been argued today, but I'm more than happy to move forward with it. I just want to make it for the record that should this case continue on, should they somehow prevail, which I don't think they will, but if they do, I don't want to see some sort of anti-SLAPP or some other suit like that claiming that this should have never been brought in the first place, but it should have been fought now. So I'm happy to move on, but I just want to raise my concern with the court. They've got the thing that basically says we don't oppose on procedural grounds, but we do really oppose that they have any kind of claim to begin with. I just think they're trying to set up something later on that they should argue now, but again, I'm fine dealing with it later. I just want to put it on the record.
Well, it seems to me that you've indicated that there's a post-complaint and intervention, right? All right. That would be served and filed, and then whatever contentions are going to be made in response to that would be addressed.
And that's fine. I just want to break it for the record.
So
I will submit an order, run it by counsel, submit it to Your Honor, and then we will file a complaint intervention. Okay.
Is that going to be intervention of right or permissive or?
What would you like to order, Your Honor? I think we're entitled to both. I can make it on both grounds. I can make it on either ground, whatever you feel is appropriate.
I think you can go ahead and make it on both grounds at this point, and go ahead. The motion's granted. Submit a proposed order, run it by opposing counsel, serve and file the complaint and intervention, and then that'll be subject to response.
And again, just for the record, I believe under NRCP 24 that the complaint and intervention is served pursuant to Rule 5, which is just the normal service through the e-service.
Right.
Okay. So I just want to make sure when you say file and serve.
And that's without prejudice to whatever, right, that's without prejudice to whatever contentions there are that you've
I appreciate that, Your Honor. I just want to make sure for the record that we're not required to actually personally serve it through a process service.
No, it's parties of record, counsel of record, electronically.
Perfect. Thank you so much for your time.
Your Honor, may I be heard?
Yes.
This is Joel Tasca for the Review Journal. Because counsel made that statement about the, anti-SLAPP needs to be argued today, I need to put on the record that we object to that. We in no way, shape, or form waive any argument whatsoever or our ability to bring an anti-SLAPP motion. We are here to say that we don't oppose that the standards for Rule 24 intervention are met, but we think that it would be ridiculous to make us go forward and argue all of our merits issues today.
No, I just indicated I'm granting the motion without prejudice to whatever your contentions are brought before the court as appropriate once the operative pleading has been served and filed, and I'll address them at that time.
Understood, Your Honor. Thank you.
Thank you, Your Honor.
All right, thank you.